फ्रेंड्स, मैं थोड़ा अपना वीर अशोक अरोड़ा एडवोकेट अज काफ़ी इंपॉर्टेंट टॉपिक्स शेयर करूंगा ਜਿਹੜੇ ਕਿ ਸਰਫੈਸੀ ਐਕਟ LOC ਨਾਲ ਕਨੈਕਟਡ ਕੇसेस DRT ਦੀ ਪ੍ਰੋਸੀਜਰ ਗਰੰਟਰ ਦੀ ਲਾਇਬਿਲਿਟੀ ਐਂਡ ਸੋ ਮੈਨੀ ਅਦਰ ਰਿਲੇਟਡ ਇਸ਼ੂ ਮੈਂ ਤੁਹਾਡੇ ਨਾਲ ਸ਼ੇਅਰ ਕਰਾਂਗਾ। ਇਹ ਸ਼ੇਅਰ ਕਰਨ ਤੋਂ ਪਹਿਲਾਂ ਮੈਂ ਤੁਹਾਨੂੰ ਇੱਕ ਬੇਨਤੀ ਕਰੂੰਗਾ ਕਿ ਇਹ ਵੀਡੀਓ ਥੋੜੀ ਜੀ ਲੈਂਥੀ ਹੋ ਸਕਦੀ ਹੈ ਕਿਉਂਕਿ ਇਸ਼ੂ ਜ਼ਿਆਦਾ ਹੈ ਤੇ ਇਸ ਦੇ ਲਈ ਜੁੜੇ ਰਹਿਣਾ, ਵਿੱਚ ਦੀ ਆਰਾਮ ਕਰ ਲੈਣਾ, ਪਾਜ਼ ਕਰ ਲੈਣਾ, ਫਿਰ ਚਲਾ ਲੈਣਾ। ਪਹਿਲਾਂ ਮੈਂ ਫੈਕਟਸ ਆਫ ਦੀ ਕੇਸ ਤੁਹਾਨੂੰ ਦੱਸਣਾ ਚਾਹਾਂਗਾ। ਇੱਕ ਪਰਸਨ ਨੇ ਇੰਡਸਟਰੀ ਖੋਲਣ ਦਾ ਮਨ ਬਣਾਇਆ। ਹੀ ਵਾਜ ਹੈਵਿੰਗ ਰਿਚ ਪ੍ਰੋਪਰਟੀ ਬਟ ਨਾਟ ਹੈਵਿੰਗ ਟੂ ਮਚ ਕੈਸ਼। ਹੀ ਅਪਰੋਚ ਦੀ ਬੈਂਕ ਨੇ ਉਹਦਾ ਲੋਨ ਸੈਂਕਸ਼ਨ ਕਰਤਾ। ਉਸ ਨੂੰ ਹੋਰ ਲੋਨ ਦੀ ਥੋੜੀ ਜਿਹੀ ਲੋੜ ਪਈ ਤਾਂ ਉਹਨੇ ਆਪਣੇ ਦੋਸਤ ਨੂੰ ਕਿਹਾ ਵੀ ਤੂੰ ਮੇਰਾ ਗਰੰਟਰ ਬਣ ਜਾ, ਤੇਰੀ ਪ੍ਰੋਪਰਟੀ ਹੈਗੀ ਹੈ ਤੇ ਮੇਰਾ ਜਾਮਨ ਬਣ ਜਾ ਤੇ ਮੈਨੂੰ ਲੋਨ ਹੋਰ ਮਿਲ ਜੂਗਾ। ਫਾਸਟ ਫਰੈਂਡ ਸੀ, ਉਸਨੇ ਆਪਣੀ ਪ੍ਰੋਪਰਟੀ ਵੀ ਨਾਲ ਪਲੇਜ ਕਰਾਤੀ, ਗਰੰਟਰ ਬਣ ਗਿਆ। ਫੈਕਟਰੀ ਚੱਲਦੀ ਰਹੀ, ਅੱਛਾ ਪ੍ਰੋਡਕਟ ਹੁੰਦਾ ਰਿਹਾ, ਪ੍ਰੋਗਰੈਸ ਕਰਦੀ ਰਹੀ। ਇਸ ਤਰ੍ਹਾਂ ਕਰਦੇ ਕਰਦੇ ਉਸਨੇ ਆਪਣੇ ਦੋਸਤ ਨੂੰ ਕਿਹਾ ਵੀ ਹੁਣ ਤੇਰੀ ਫੈਕਟਰੀ ਚੱਲ ਪਈ ਹੈ ਕਿ ਮੇਰੀ ਪ੍ਰੋਪਰਟੀ ਰਿਲੀਜ਼ ਕਰਾ ਦੇ ਤੇ ਆਪਣੀ ਜਿਹੜੀ ਹੋਰ ਪ੍ਰੋਪਰਟੀ ਨੂੰ ਅਟੈਚ ਕਰਾ ਕੇ ਬੈਂਕ ਦੀ ਫਾਰਮੈਲਿਟੀ ਪੂਰੀ ਕਰ ਲੈ। ਉਸਨੇ ਉਹਦੀ ਪ੍ਰੋਪਰਟੀ ਰਿਲੀਜ਼ ਕਰਾਤੀ, ਆਪਣੀ ਹੋਰ ਐਡੀਸ਼ਨਲ ਪ੍ਰੋਪਰਟੀ ਲਾਤੀ ਤੇ ਇਸ ਤਰ੍ਹਾਂ ਕਰਕੇ ਉਹ ਫੈਕਟਰੀ ਚੱਲਦੀ ਰਹੀ। ਉਸ ਬੰਦੇ ਦੀ ਪ੍ਰੋਪਰਟੀ ਰਿਲੀਜ਼ ਹੋਈ ਆਪਣੇ ਮਿਊਨਿਸਪਲ ਕਾਰਪੋਰੇਸ਼ਨ ਦੇ ਕਾਗਜ਼ਾਂ 'ਚ। ਉਹਨੇ ਜਾ ਕੇ ਉਹ ਆਪਣੀ ਸਾਰੀ ਪ੍ਰੋਪਰਟੀ ਨੂੰ ਐਸ ਸੱਚ ਰਿਸਟੋਰ ਕਰਾ ਲਿਆ, ਪਲੈਜਿੰਗ ਉਹ ਤੋਂ ਖਤਮ ਕਰਾਤੀ ਤੇ ਉਸ ਨੂੰ ਅੱਗੇ ਰਿਜ਼ਲਟ ਨਹੀਂ ਪਤਾ ਸੀ ਵੀ ਗਰੰਟੀ ਦੇਣ ਦਾ ਕਿੰਨਾ ਅੱਗੇ ਨੁਕਸਾਨ ਹੋ ਸਕਦਾ ਹੈ। ਸੋ ਵੀਰੋ, ਕਿਤੇ ਗਰੰਟੀ ਦੇਣੀ ਹੈ ਤਾਂ ਸੋਚ ਸਮਝ ਕੇ ਪਹਿਲਾਂ ਤਾਂ ਗਰੰਟੀ ਦਿਓ। ਤਾਂ ਹੁਣ ਮੈਂ ਮੇਨ ਟੌਪਿਕ ਤੇ ਆਉਣਾ ਤੇ ਆਪਣਾ ਇਹ ਪ੍ਰੋਜੈਕਟ ਸ਼ੁਰੂ ਕਰ ਰਿਹਾ ਹਾਂ। ਇਹਦੇ ਵਿੱਚ ਮੇਨ ਜੋ ਮੈਂ ਇਸ਼ੂ ਕਵਰ ਕਰਾਂਗਾ ਮੈਂ ਤੁਹਾਨੂੰ ਇੱਕ ਵਾਰੀ ਪੜ੍ਹ ਦਿੰਦਾ। ਇੱਕ ਤਾਂ ਲੁੱਕ ਆਊਟ ਸਰਕੂਲਰ ਬਾਰੇ ਡਿਟੇਲ 'ਚ ਡਿਸਕਸ ਕਰਾਂਗਾ, ਮੇਨ ਫੋਕਸ ਇਸ ਤੇ ਰਹੇਗਾ। ਤੇ ਲੁੱਕ ਆਊਟ ਆਊਟਰ ਜੋ ਸਰਕੂਲਰ ਕੌਣ ਇਸ਼ੂ ਕਰਦਾ, ਦੈਟ ਇਜ਼ ਬਿਊਰੋ ਆਫ ਇਮੀਗ੍ਰੇਸ਼ਨ, ਉਹਦੀ ਵਰਕਿੰਗ ਬਾਰੇ ਡਿਸਕਸ ਕਰੂੰਗਾ। ਬੈਂਕ ਆਪਣੀ NPA ਨੂੰ ਕਨਵਰਟ ਕਰਨ ਵਾਸਤੇ, ਕਵਰ ਕਰਨ ਵਾਸਤੇ ਕਿਵੇਂ ਬਾਰੋਵਰ ਤੋਂ ਆਪਣੇ ਪੈਸੇ ਕਢਾਉਂਦਾ ਹੈ, ਸਰਫੈਸੀ ਐਕਟ ਬਾਰੇ ਤੇ DRT ਐਕਟ ਦੀਆਂ ਪ੍ਰੋਵੀਜ਼ਨਾਂ ਬਾਰੇ ਡਿਸਕਸ ਕਰੂੰਗਾ। ਤੇ ਇਸ ਤੋਂ ਇਲਾਵਾ ਪੁਆਇੰਟਸ ਜਿਹੜੇ ਹੈਗੇ ਆ ਅੱਗੇ ਰਿਟ ਪਟੀਸ਼ਨ ਬਾਰੇ ਵੀ ਡਿਸਕਸ ਕਰਾਂਗਾ। ਜਦੋਂ ਸਾਰੇ ਸਿਸਟਮ ਅੱਗੇ ਫੇਲ ਹੋ ਗਏ ਤੇ ਜੋ ਬਾਰੋਵਰ ਹੈ ਜਾਂ ਗਰੰਟਰ ਹੈ, ਅਗਰੀਡ ਪਾਰਟੀ ਹੈ, ਅੰਗੇਜ ਬੈਂਕ ਜਾਂ ਬਿਊਰੋ ਆਫ ਇਮੀਗ੍ਰੇਸ਼ਨ, ਤਾਂ ਉਹ ਰਿਟ ਪਟੀਸ਼ਨ ਫਾਈਲ ਕਰਕੇ ਆਪਣੀ ਰਿਲੀਫ ਮੰਗਦੀ ਹੈ। ਤਾਂ ਉੱਥੇ ਜਿਹੜੇ ਪੁਆਇੰਟਸ ਰੇਜ਼ ਹੋਏ ਉਹ ਵੀ ਮੈਂ ਤੁਹਾਨੂੰ ਦੱਸ ਦਿੰਦਾ, ਜਿੱਥੇ ਅੱਗੇ ਆਪਾਂ ਚਾਨਣਾ ਪਾਵਾਂਗੇ। that will be purely in English. First one is, can a lookout circular be issued against grantor whose property has been returned but he is again told by the bank to be a grantor in person? Second is the copy of LOC must be provided to the person against whom LOC is issued? Third one is, can the passport be endorsed as cancelled so that he may not go outside? Is it good? Is it not the violation of Article 21? Next one is constitution right to go abroad. One has freedom. He can go if he has given guarantee. That is too simple personal guarantee. Can he be stopped from going outside country, in foreign country? Sections of the Sarfaesi Act automatically will come into play. Then various office memorandum or will be said how the LOC is issued. What are the memorandums? What are the provisions that I will discuss in this issue? Procedure to be adopted by the Bureau while issuing LOC. LOC ਕਿੰਨੇ ਤਰ੍ਹਾਂ ਦੇ ਹੁੰਦੇ ਆ? Types of LOC. LOC issue ਕਰਾਉਣ ਵਾਸਤੇ ਆਫਿਸ ਬੈਂਕ ਦੇ ਆਫਿਸ ਦੇ ਕਿਹੜੇ ਆਫੀਸਰ ਆਥੋਰਾਈਜ਼ਡ ਹੈ? ਕਿਉਂਕਿ ਇਟ ਇਜ਼ ਸੀਰੀਅਸ ਮੈਟਰ to issue lookout circular against anyone. So senior officers are allowed. I will discuss that. And the validity period of LOC. These things I will discuss. Now let us start discussing. The firstly, when the debtor is defaulted of his commitments, he is not returning the money as committed, then the internal phenomena is there of the banking industry. They see whether this product of loan is giving us a return or it has been converted into NPA, non NPA. Then they proceed further. When this was declared as NPA, then they issued notice to the unrestricted debtor, giving proper time under Section 13, and he did not respond. Then they applied to the debtor recovery tribunal. While the debtor recovery tribunal had taken the things which were shown to him through his application, he came to know that there is one more person involved in the guarantee, that is having a guarantee in person. So they adopted the procedure to locate that person. When neither the debtor was locatable, could not be found, nor the person in personal guarantee could be found, then they requested the Bureau of Immigration to issue lookout circular. The problem arose here. DRT and Bureau of Immigration should have taken the things in judicial manner. What the Bureau of Immigration mechanically ordered lookout circular. Then the aggrieved person was not aware of it. His family, children, grandchildren are residing in Canada, and with his wife was residing in India. So he got visa for going to Canada. And when he was just to board the plane, he was stopped under this LOC. Not being aware of things, he put in conversation with the authorities. Why do you are doing so? I am not at fault. I am not a criminal. Let the things, what happened, they allowed his wife to go to Canada. He boarded the aeroplane and he was stopped. He consulted so many advocates that my fundamental right has been violated. From where this situation arose, then he approached the Honorable High Court of Punjab and Haryana at Chandigarh, White CWP 19018 of 2022, which was reserved for decision up to 28th of September 22, and later on 17th October 22, the decision was given. In this case, the main stress was on how the LOC can be issued against the person. Now, coming in court language way, I am telling you first the background of the case. The petitioner has challenged in this writ petition a lookout circular issued against him by the Bureau of Immigration, New Delhi, on the basis of which petitioner was prevented from traveling abroad to Canada. Petitioner is a personal guarantor to the loan availed by the debtor company from the bank and had executed a equitable mortgage of residential property belonging to him. Subsequently, the company had substituted some other property also in addition to the property already mortgaged by it, and the property for which the petitioner has had executed an equitable mortgage was released, and a letter was sent to the Secretary Municipal Council where his property was lying to make necessary entries in that regard. But later on, company defaulted in repayment of loan to the bank, and bank filed AO number 1541 of 2021 before the Debt Recovery Tribunal to Chandigarh for recovery of, this was major amount, 6.90 crore. Petitioner means grantor in person, has two children who are living in Canada, and petitioner intended to visit them. So he secured a visitor visa from the Canadian government and also booked a ticket on an Air India flight to Toronto, Canada for himself and his wife. But the petitioner was not allowed to board the flight on the ground that LOC was issued against him. Petitioner's wife was, however, allowed to board the flight and to go to Canada. And the three members of the petitioner family are in Canada, but the petitioner is not being allowed to travel to Canada. Petitioner contends that copy of LOC was not provided to him. Petitioner alleges that the said LOC was issued since he was guarantor for the loan advanced to the company by the bank, which had been defaulted by the company. He also contends that an endorsement was made on his passport called as cancelled stamp. Petitioner also contends that an order was also granted in favor of the bank in AO number 1541 of 2021, staining the defendants in this application from alienating the secured assets of any third party till the disposal of you. The petitioner further contends that he has a constitutional right to go abroad, and such a right cannot be prevented from being exercised without due process of law and without observing principles of natural justice. He further contends that he is not an accused in any criminal case, nor is he evading the process of law, and no criminal case was registered against him. According to him, there was no declaration that he had committed any fraud or that he is a willful defaulter by any competent authority as per law, and so no LOC could be issued against him. Petitioner also contends that principles of natural justice require that LOC issued against him should also be furnished to him. In any event, since the petitioner's property has already been released by the bank merely because he was wrongly implemented as a party in the AO filed by the bank could not have sought for issuance of LOC against him. Now, what is the stand of the respondents? That is, one is bank, second one is Bureau of Immigration. Our respected, I will say, most respected Additional Solicitor General of India, Mr. Satyapal Jain, appeared for them and has placed before the court the request made by the respondent bank seeking LOC against the petitioner and also LOC number issued against the petitioner. A reading of the request made by the bank to the Bureau of Immigration clearly reveals that such a request for opening of an LOC was made against the petitioner on the ground that the loan account of the debtor has become an NPA and that the petitioner is one of the guarantors to the said loan. And they were relying on the letter issued by the Department of Financial Services empowering the chairman, managing director, chief executive of all public sector banks to issue requests for opening LOC against persons covered under the Office Memorandum dated 27th October 2010. I am going to read this memorandum in detail later on. Further, Mr. Satyapal Jain contended that petitioner is not entitled to be given a copy of LOC. The LOC was issued against him and it is the respondent number 2 to defend the issuance of LOC. He has no purpose to defend the LOC. The second respondent 2 filed a reply contending that the petitioner stood as a guarantor to the loan, guarantor to the debtor, and had executed a guarantee agreement that he also mortgaged his property in order to secure the repayment of loan facilities granted to debtor. That loan account of the debtor was declared as an NPA and the process under the Sarfaesi Act was initiated by serving notice under Section 13(2) of the Sarfaesi Act for recovery of 6.28 crores. It is also alleged that in spite of receipt of the said notice, petitioner did not clear the outstanding dues and the respondent then filed OA 1541 of 2021 by impleading the petitioner as defendant number 6. It is contended that respondent number 4, that is debtor, was declared a willful defaulter and this was communicated to the RBI also. It is asserted that respondent number 2 approached the respondent number 3 for issuance of LOC and later dated 8th July 21 was issued on the basis of which the impugned LOC was issued. They said that we acted in accordance with the rules and it had not acted in a malified or biased manner against the petitioner. They placed reliance on the letter dated 22nd November 2018 issued by the Ministry of Finance referred to permitting financial institutions and banks also to seek issuance of LOCs in cases which are not covered by the guidelines in larger public interest and economic interest of India. It is contended that even if the property of the petitioner was released by the bank, the petitioner's guarantee continues. This is the main point of dispute. When the bank has released his property, that we do not require the guarantee of this your property, still the petitioner is guarantor. This is the main point. It is also contended that petitioner intends to flee the country and if the LOC is not there, there is a possibility that he would keep himself away from the reach of the bank. It is stated that the presence of the petitioner is required by the bank to take steps to recover their dues. Now, listening to both the parties, the court came to the consideration what are the questions involved. Then they decided the question to be considered are number one, whether the LOC issued at the instant of the bank against the petitioner can be sustained in law or not, whether merely on the ground that petitioner is a grantor for the loan taken by the debtor and there is default by the said debtor, can the petitioner be prevented from traveling abroad and his fundamental rights under Article 21 of the Constitution of India are not being curtailed. Now, coming to important judgment, that is Menka Gandhi versus Union of India. And second one is Satish Chandra Verma versus Union of India. The right to travel abroad has been recognized by the Supreme Court of India in the case of Menka Gandhi versus Union of India and Satish Chandra versus Union of India as falling within the scope of personal liberty enshrined under Article 21 of the Constitution of India. That to deny a person such a right requires a very high threshold. The order should not be a mechanical one. The issue of the LOCs in respect of Indian citizens and foreigners was initially governed by the Office Memorandum number so and so, dated so and so. In this Office Memorandum, reference is made to certain judgments of the Delhi High Court, and it is as under. Firstly, this Office Memorandum number 25016 of 2010 Immigration, dated 27th of October 2010, gives certain guidelines. One is recourse to LOC can be taken by the investigating agency in cognoscible offences under IPC or other penal laws, where the accused was deliberately evading arrest or not appearing in the trial court despite non-available bonds and other measures, and there was likelihood of the accused leaving the country to await trial or arrest. Second was the investigating officer shall make a written request for LOC to the officer as notified by the circular of Ministry of Home Affairs giving details and reasons for seeking LOC. The competent officer alone shall give directions for opening LOC by passing an order in this respect. Third one was the person against whom LOC is issued must join investigation by appearing before investigating officer or should surrender before the court concerned or should satisfy the court that LOC was wrongly issued against him. He may also approach the officer who ordered issue of LOC and explain that LOC was wrongly issued against him. LOC can be withdrawn by the authority that issued and can also be withdrawn by the trial court where case is pending or having jurisdiction over the concerned police station on an application by the person concerned. Next one was the LOC is a coercive measure to make a person surrender to the investigating agency or the court of law. The subordinate court's jurisdiction in affirming or cancelling LOC is commensurate with the jurisdiction of cancel of non-bailable bonds or affirming the non-bailable bonds. The said office memorandum mentioned a list of officers of various departments of the government who can make a request for opening of LOC. Now I am discussing the officer in power too. Now coming to clause H of the Babu circular, it states in cases where there is no cognizable offense under IPC or other penal laws, the LOC subject cannot be detained, arrested, or prevented from leaving the country. The originating agency can only request that they be informed about the arrival, departure of the said subject in such cases. Only information, no arrest can be made. Only information of the subject is to be given. Thus, LOCs were permitted to be opened essentially engaged persons involved in cognizable offences and who were evading arrest and not appearing in trial courts despite non-availability or other coercive measures. And there was a likelihood that they would leave the country to await trial or arrest. It was intended as a coercive measure to make a person surrender to the investigating agency or the court of law. But where the subject of the LOC is not involved in any cognizable offense, he or she cannot be detained or arrested or prevented from leaving the country. The originating agency can only request that they be informed about the arrival, departure of the subject in such cases. The office memorandum stated that LOC would be valid for a period of 1 year from the date of issue. This is the answer to third question. It is only for 1 year. There are subsequently amendments made to the office memorandum from time to time. In another amendment, paragraph 8 subclause J was inserted in the office memorandum through another office memorandum. What it says, para 8J says, in exceptional cases, LOC can be issued even in such cases as would not be covered by the guidelines above, whereby departure of a person from India may be declined at the request of any of the authorities mentioned in Clause B of the above memorandum. If it appears to such authority based on the inputs received that departure of such person is detrimental to the sovereignty or security or integrity of India, and or that the same is detrimental to the bilateral relations with any country or to the strategic or economic interest of India. Or if such person is allowed to leave, he may potentially indulge in an act of terrorism or offenses against the state, or that such a departure ought not be permitted in the larger public interest at any given point of time. Well, if he is involved in the type of serious charges, the accusation, then it can be he refused. Initially, managing directors and CEOs of the public sector banks were not authorized to make requests for opening of LOCs. But later on, an office of memorandum dated 4th October 2018 was issued to include them also in the list of authorities who can seek LOC. So I mean to say now, managing directors and chief executive officer of the public sector banks are authorized to request for LOCs. This was done in view of the paragraph 8J being inserted in the office memorandum dated 27th October 2010 to enable LOC to be issued against the persons who are fraudsters, persons who wish to take loan, willfully default, launder money, and then escape to foreign countries. Since such action would not be in the economic interest of the India or in the larger public interest. What the amount of default by a person which would not be in the economic interest of India or in the larger public interest for which an LOC can be sought and issued is not mentioned in the set of the memorandum. Well, there is gray area. How much amount will qualify for economic interest of India or in the larger public interest? However, taking advantage of the said office memorandum, request for LOC are being issued by the public sector banks against persons defaulting in payment of loans due to them, like in this instant case, the LOC has been issued. The contention of the bank that economic interests of India are affected by the non-payment of dues of defaulter by the petitioner to it cannot be accepted since the amount of loan defaulted by a person would not be in the economic interest of India or in the larger public interest is not mentioned in the set of memorandum issued by the Ministry of Home when they do not themselves draw any line about the quantum of default by a borrower to a financial institution which would be considered detrimental to the economic interest of India, assuming for the sake of argument without considering that it is affected at all, and a quantum of default which would not fall in the said category, the fundamental right to travel abroad granted by the Article 21 of the Constitution of India cannot be curtailed by the respondent number 2 by seeking issuance of LOC. Merely because the word public is used in exception clause in the OM, it does not elevate a mere default to an exceptional plan. It cannot be said that the departure of the petitioner from the country would adversely impact the economy of the country as a whole and destabilize the entire economy of the country. Since the right to travel abroad flows from the Article 21 of the Constitution of India, a very high threshold is mandated to deny such a right to an Indian citizen. Such a threshold is not met in this instant case. The request dated in the year 21 made by the bank to respondent Bureau of Immigration produced before us shows no reason as to why such LOC is being sought in his petition. So it appears that bank has not applied his mind to the request as well as Bureau has not applied his mind for the issuance of LOC. So and did not consider whether ground disclosed therein fall within the four corners of OMs issued in that regard. Though it may not be able to go into the merits of the allegation made against the petitioner by the bank, it appears that mechanically the Bureau has issued the LOC and the instance of bank. Similar view already has been expressed by this court in Poonam Pal versus Union of India and in Noor Pal versus Union of India. It was further held that in those decisions that non-supply of LOC to the subject of the LOC at the time of issuance of the same and denial of opportunity to the subject of the LOC, a post-decisional hearing to explain why such LOC should not be issued against them, should not be withdrawn, cancelled by the Bureau of Investigation, is arbitrary and illegal, and it cannot be said to have followed fair, just, and reasonable procedure to deprive the subject of the LOC of his or her fundamental right to go abroad. We follow the said decision rendered by the division bench of this court and hold that bank cannot make a request for issuance of LOC to the Bureau of Immigration in respect of dues owned by the petitioner to it as per office memorandum issued by the Ministry of Home Affairs from time to time. Therefore, LOC issued and extended by the Bureau of Immigration at the instance of respondent bank cannot be sustained. Admittedly, Office Memorandum dated 27th October 2010 issued by the government, LOC can be issued, among us other authorities, for committing cognitive offences under the Indian Penal Code of 1860 or any other penal law, where the accused deliberately evades arrest or does not appear before the trial court despite non-bailable grounds, or there is likelihood of the accused to leave the country to await trial arrest. It is not the case of respondent that a petitioner is accused of having committed a cognitive offence in India. So, as per Clause H of the Office Memorandum extracted above, Clause 1 of the latest Office Memorandum extracted above, in cases where there is no cognitive offence under IPC or other penal law, LOC subject cannot to be detained, arrested, or prevented from leaving the country. The originating agency can only request that they be informed about the arrival departure of the subject in such cases. In the instant case, when the petitioner is not alleged to have committed any cognitive offence, he could not have been prevented from leaving the country by the respondent by issuing LOC, and such action is clearly violative of the Office Memorandum of 2010 and 2021. Only accordingly, the writ petition is allowed. LOC issued against the petitioner at the instant of the bank by the Bureau of Immigration is set aside and petitioner is permitted to travel abroad. The stamp endorsement cancelled put on his passport is request. Respondent shall expunge any remark, endorsement, entry that might have been made in the record or passport of the petitioner with respect to pub LOC. Respondent bank shall communicate this order to the respondent number 3 and officials, employees of the respondent number 1 and 3 are restrained from preventing the petitioner from traveling abroad. The respondent shall also pay cost of 20,000 to the petitioner within 4 weeks from the date of receipt of the copy of this order. Pending application, if any, shall also stand disposed. So the court took a serious view in this case. In the end, I will request you all, if there is any pronunciation mistake or something else, please excuse me, as I have studied from the rural school of my time. Thank you for watching. Don't forget to subscribe, like, and share with others. Once again, thank you.